I should appreciate our board member Ram, who arranged for this one. I think currently he is not in this call, but appreciating that. So it's always it's an unknown area for so many people, because we may not be we may not hear all these important things which we have to be little proactive and do it ourselves. So I think this is a very helpful session. So without much delay, I would hand over the dice to Mark to take it forward. Thanks, Mark. You can carry on. Yeah.
Great. Yeah. Thanks, Nita. So welcome everyone to this important topic of estate planning. So tonight we'll cover a couple of things. We'll talk about what estate planning is, what it means, and all the documents that you get in a full comprehensive estate plan and why each of those documents are so important. And then we'll turn it around and we'll talk about, well, what happens if something happens and we don't have these documents? One key thing to remember is over here in the US, it's very complicated if you don't have estate planning. It's very easy if you do, but we leave a lot of things up to chance and up for other people to come in and dictate what happens if we don't have these plans. So we're going to cover all of that tonight. So let me share my screen, and that way you can follow along with the presentation instead of having to look at me, right? So let's look at what's important here. And as the screen says, when we talk about estate planning, what are we doing? We're protecting our wealth and our health. That's what we do every day at NetLaw. We help our clients create their full comprehensive estate plan so that they are protected, their spouse is protected. And of course, we want to make sure that everything that we have gets distributed easily and at the best cost-effective way. We want to take care of our kids and make sure that they're well taken care of if anything happens. So we're going to go through all of this tonight, and then later we'll answer any questions that you have. But I think the first thing to talk about is, well, what is NetLaw? So NetLaw is an IT company that was created out of an estate planning law firm in Louisville, Kentucky called the Hargrove Firm. Now, that's where I'm at. I am Mark Stirneman. I am the vice president of NetLaw. And the reason that our law firm created our sub-company NetLaw was because back in 2012, we read in a Bloomberg report that said that over 60% of Americans do not have their will. Just that one document, over 60% of Americans do not have this. And, you know, you can ask anyone, hey, do you have your will? And most people will say no, but they seem to always follow up with, I know I need to do that, right? So we know how important having a will is, but yet, again, 6 out of 10 people procrastinate on doing this. So we did some research to find out, well, why is it that people procrastinate? And there were two major reasons that stuck out. I think we can all guess what number one is. Cost, right? It is expensive to come in and speak to one of us and get your estate planning documents created by an attorney in our law office, right? But the second reason that we found out was even more scary than the cost factor. No one wanted to go see attorneys anymore, right? You just think about everything that we can do now online. We can buy a house online. We can buy a car online. We can refi online. So we said, okay, if we can do all of this, why can't we have the ability to create a software that can create your estate planning documents? And that's what we did. So we created our sub-company, NetLaw, and we went out and we hired attorneys in all 50 states. So the reason that we went out and hired attorneys in all 50 states, because each state has their own rules and regulations that have to be followed by the American Bar Association. You may know them as state-specific documents. That's the popular term, but it's rules and regulations of every estate plan that each state has for their citizens. So again, NetLaw went out, we hired attorneys in all 50 states, and we had a lead attorney come in and help us create our software. So NetLaw is a document creation company that went out and has attorneys that come in and create our software. So we have a California attorney that came in and created the California documents. We have a Texas attorney that came in and created our Texas documents, so on and so on and so on for all 50 states and DC. Back in 2012, when we were created and we launched this, we were lucky enough and honored enough to win the James Keene Award from the American Bar Association. Now, this is a very important award because this award goes out each year to the company that has the best online delivery of legal documents. And I'll say that again, the best online delivery of legal documents. That's from the American Bar Association. And still to this day, we are the only ones in estate planning to ever win this award from the American Bar Association. So not LegalZoom, Legal Shield, Trust and Will, all the companies that you've heard of. NetLaw is the only one to win the James Keene Award from the American Bar Association. And what documents do you get? Everything that you see here, you get in our full comprehensive probate avoidance package. And we're going to run through all of these documents, and I'll take some time to explain why each of these documents are so very important. And the one thing to remember about NetLaw is we sell a full comprehensive plan. With most other companies, you can come in and just buy the power of attorney. But then you have to buy the power of attorney for your spouse. Or you might want to just come in and get your HIPAA authorization. But then you have to buy it through the, we don't do that. We give you a full comprehensive plan that serves both spouses. So the great thing to remember is one plan covers both spouses' documents. So let's talk about these documents and why they're so important. And the first one that I'm going to start off with is the last will and testament. And there's really 4 reasons why we do our will. One, we get to name executors. Your executors are going to be anyone who is over the age of 18, but these are the people who are going to be in control when you pass away. These are the people who will be paying our taxes after we pass away, paying all of our creditors, making sure that all of our assets get to our beneficiaries. To me, probably the most important person that you're going to name in your documents because they are going to handle everything. One thing that I always get is, can one of my executors be from overseas? Absolutely. Yeah. Now, we would prefer that you name at least one person as a resident here of the U.S. in the state that you reside in, because if something unexpected happens, they're the first people who are going to react. So, you know, if it's someone from here, they can react right away and start taking care of everything. Again, your executors have to be over the age of 18. And not only do you name main executors, but you get to name alternate executors as well. So someone who can fill in the role if the first person that you name can't do it. Second reason we do our will, guardians. So if you have a child or children under the age of 18, something happens to you and your spouse, a car wreck, a plane wreck, you know, things we went through with COVID in the beginning where, you know, in our law office, people come in, yeah, mom and dad both died of it. It did happen, unfortunately. But we always want to make sure that we have someone listed. So if something happens to mom and dad, who's going to take care of your kids? We need to go ahead and list them as well. Again, main guardians and alternate guardians as well. The third reason that we do our will is that we get to dictate who's going to receive our assets. So we get to list all of our major assets, and then we're going to put on there a beneficiary. This asset is going to this person. And we're going to talk about what happens if we don't have these documents later, and it'll kind of bring it all full circle. And the last reason that we do our will is the second line item. It's a children's trust, or you may know it as a descendants trust. And this is for those parents that still have children under the age of 18. When do you want your child to receive their inheritance? Again, if mom and dad pass away before their age 18. Right now, if you do nothing, they will receive everything at age 18. But a lot of parents come in and say, I get it. They're 18, they're a legal adult, but still maybe a little bit too young to receive that influx of cash. With the children's trust, you can spread that out. You can spread a percentage of their inheritance, and you can give it to them at a certain age, all the way up to age 35. So very, very important. The third document here is our durable financial power of attorney. I think we all know what that is, right? Naming someone who can make our financial decisions for us if we're unable to do so for ourselves. Maybe we're sick, we're in the hospital, or maybe it's simply that you're out of the country and something happens over here. You can let your power of attorney handle everything. You don't have to rush back. So again, a very, very important document. The next three documents are our healthcare documents. Very important, just as important as your financial documents. And your healthcare surrogate is your medical POA. Who's going to speak to the doctors and nurses on your behalf if you can't speak for yourself? And your HIPAA authorization allows that person to see your medical charts so they can make an informed decision with your doctor. And the last healthcare document is your advanced directives. In some states, it's called a living will, but this is your end of life decisions. Do you want to be put on life support or not? Would you like to give any body parts to science or not, right? So we keep you in full control of everything. We even have a pet trust. So if you're a pet lover, you can leave money behind for the care of the animal that you left behind, making sure that that animal has money to pay for, vet bills, food, boarding, so that it doesn't become a financial burden to the person who takes new ownership of that animal. And then our last document is our revocable living trust. Our trust is probate avoidance. And we're going to explain exactly what probate means. So probate is the process where when you pass away, if your assets, your major assets like your home, cars, vacation homes, rental properties, businesses, if those assets aren't placed into your revocable living trust, your assets are frozen by the government, anywhere up to 6 months to a year. And what that means is all creditors have to be paid off first before any of your major assets get distributed to your beneficiaries. But you can avoid all of that by simply transferring your major assets out of your individual name and into the name of the trust. So now the trust owns those assets. But remember, you are always the trustee of your account for as long as you're alive. So you lose no authority. You don't lose any power. You are in still full control of everything, and you can sell those properties at any time. Even international property, you can put into your will and trust. And we have funding instruction sheets that walk you through how to transfer those assets into your trust. And we even have a 7-day money back guarantee. So if you try it and don't like it for any reason, as long as you haven't downloaded any of your documents, we'll give you your money back. No questions asked. Again, our full premium probate avoidance package. This is a great way that you and your spouse can take care of all of the decisions that need to be made in one plan. We sell one document by itself, and it's a special needs trust. If you are a parent of a special needs child, or you're taking care of a special needs adult, this is a third-party special needs trust. And what that means is anyone can leave an asset behind for that special needs person via their special needs trust. Here's why the trust is so important, because if you have a special needs child, then you know this. That child cannot receive hardly any asset of monetary value because it could affect their federal funding that they're receiving for the government or will receive later in life. But if that child receives an asset via the special needs trust, in the name of the special needs trust, they not only can receive that asset, but they can also receive their federal funding from the government. So very, very important. All of our documents are revocable. That means you can go in and change them at any time. This is a great option that NetLaw has, because once you pay the fee to get set up and started, there are no monthly or yearly fees. You have lifetime access to your account so that you can come in and edit your documents at any time. So very important, because most companies charge anywhere from $10 to $30 a month to keep your account open and active. We don't do that. Once you purchase the plan, again, you have full lifetime access, not only to create your documents, but to go back and edit your documents at any time. And as you probably have already read through these, you can kind of understand why editing your documents happens, right? Whether you have a new child, a new grandchild, of course, we want to add those people into our trust. But I like the one at 6 o'clock, my child turning age 18. This is very important because every person over the age of 18 needs this plan. And I know what you're thinking, Mark, come on, my child's 18, 19. They don't need a will and trust. They don't have any property, but they do need their power of attorney. They do need their medical documents for when they go off to college. If something happens to them, they're over the age of 18, mom and dad cannot come in and make any decisions for them. But if they have these documents, they can go ahead and name mom and dad, their power of attorney, their medical POA, their healthcare surrogate, so that mom and dad can still stay in control of all the decisions that need to be made. So we've talked about what NetLaw is and why NetLaw was created. And we just went through all of the documents and why they're so important to have. And we even have the ability to go in and edit our documents as we go through life and certain circumstances change. But now, the last 4 slides that I'm going to show you before I answer any questions that you have, we're going to talk about the same exact thing that we just talked about, but we're going to talk about it. What happens if you pass away and you don't have these documents? Who gets your assets? So one key thing to remember is this is not like India here in the US. It's very easy over in India for your property. Everything goes to the surviving spouse, then gets to the kids. But that's not how it works here in the US. The US has something called intestate. Intestate simply means that you passed away without a will. The government didn't know how you wanted your assets distributed, so they're going to do it for you. Every state has a will designed for the people who live in their state. And again, that's called intestate. So in Kentucky, where I'm from, our intestate rules is if I die without a will, 50% of my individually owned assets would go to my spouse. The other 50 gets sent to my kids right away. Right away. In some states, it's a 50, 25, 25 split. 50 to the spouse, 25 to the kids, 25 to your next closest living relative. And a lot of times people go, well, I didn't want my assets to be distributed like that. That's why we would create the will, right? So again, in the will, like I said when we were talking earlier, you get to list all of your assets and who the beneficiaries are, whether everything's going to the spouse or certain assets are going to different individuals. You have the ability to stay in control of everything. And this is always the first thing that I talk about when I talk to my clients when they come in and speak to me, unless I know they have children under the age of 18. What most people don't realize is if you and your spouse pass away before the kids turn 18, maybe there's a car wreck or a plane crash or something like that, right? Both spouses pass away and there's no will. A judge will come in and decide who gets custody of your children. A judge. Now, there's 33 of us on this meeting, and I can probably almost guarantee that no one on this call is saying, I want a judge to decide that, right? No way. Because we know who's best to raise our children. We know who we want to raise our kids. And the person that this judge is going to choose not only gets custody of your children, but they will be in control of their inheritance until the children turn 18. Again, another main reason of why this is so important. At all costs, we want to avoid probate court for our beneficiaries. By creating that trust, again, we have the ability to transfer those assets out of our name and into the name of the trust so that the beneficiaries receive those properties right away. if you choose to not do it and have your beneficiaries go through probate court, it's going to be very frustrating for them. They have to hire an attorney. They have to go to court. It's very expensive. And the time that it takes to get those assets out of probate court and into the hands of the beneficiary can easily last up to a year. And my last screen. Don't forget how important these medical decisions are. Having that medical power of attorney so someone can speak for you if you can't speak for yourself is very important. These documents come in play a lot for people of our age who have their parents still alive. And maybe their minds aren't as sharp as they once were, right? We have the ability to go in and talk to the doctors and nurses on their behalf and having them create their advanced directives while they're still young. What do you want to happen at end of life? What are your decisions that you want to have happen? We create these documents now for when we need them in the future. Very, very important. We can't make them if we're unconscious. We can't make them if we're not in our right state of mind, right? So we need to create these documents now before things happen later. So Sento or Chandru, I will turn it back over to you guys. And if there's any questions that anyone has, I'll answer them now. This was kind of a quick estate planning 101 that really talked about protecting our assets, protecting our children, and our medical documents, making sure, again, that we have a well-rounded, fully comprehensive plan in place before it's too late. So Sento, I'll turn it back to you.
Thank you. So I think like we can turn the table for the question and answers. We have some of the questions already sent by the other participants, but in the call, no, whoever is there in the call, do you guys have any questions right now to Mark? You can unmute yourself and or raise your hand so that you can talk and we can get the clarifications.
Yeah, I have one question. Yeah, hi, this is Kavi here. So my wife has taken a EREG legal plan through her employer, and we tried to check. They have a couple of attorneys through that plan, and they said will cost will be covered under that plan. So wanted to check, do your attorneys covered under that?
Well, we're not part of any employer benefits. So the answer to that would be no. We don't work with the employer benefit companies like NetLaw. Now, here's the difference why. Usually, if you're using an employer benefit, you're not getting all of these documents. We want to make sure that you have a fully comprehensive plan. And usually you only get to talk to the attorney once or twice. After that, you're kind of on your own. So we want to make sure that you're doing a full apples to apples comparison. But I'll tell you, Cavi, most people, if you go to your HR department or have your wife go to her HR department and ask them, hey, if I buy this, can I give you a receipt and get refunded back for it? A lot of them say yes. So I would have her do that. And let's see if we can get you on this full comprehensive plan.
Okay, sure. Thank you. We'll check.
Sure. Yeah, good question.
Anyone else have the questions?
Yeah, I'll answer the one in the chat.
Yeah, from the chat, Mark, I think what I see that was the first question. How do I do a will alone for a single parent? So I think it looks like he or she is the single parent, and his question is how can I do that?
Yeah, same way. So whoever invited you to this meeting, let's get with them, and they can send you a email that will allow you to get into the system. And if you just want to create a will, great. For a single person, you don't have to be married to do this. So you can go in and create your will and trust all for yourself. And maybe later in life, you do get married or you get remarried again. I don't know what your situation is. But yeah, if you get remarried, you can have your new spouse added in for free.
Thanks, Mark. I think like one other common question, I have been hearing the same question asked here as well. So if we have a will taken, why do we need trust? The other way around also, no? If I have the trust, why do I need will?
Yeah, absolutely. So your will, think of it as this. Your will is your listing document. So we're going to list everything in the will. We're going to list who our executors are, who our guardians are, what assets we have, and who those beneficiaries are, right? We're doing that in the will. But by transferring those assets out of our individual name and into the name of the trust, when we pass away, those assets get distributed to our beneficiaries right away. This is why we have the will, or I'm sorry, the trust. The trust is the only document that avoids probate. If you have a will without a trust, everything's going through probate. That means those assets will not be distributed for a minimum of 6 months, and it could go all the way up to a year. So it just depends. If you want your beneficiaries to wait and not get these assets right away, you don't have to do a trust. But I can't imagine anybody wanting that when you have the ability to do that and get them those assets right away.
Thanks, Manoj. I think that is a really good thing. Even some of the people, they were asking like, I don't want to trust somebody, like, why do I need to trust the third person, kind of things. So can I just have the will alone without doing the trust?
Sure, you can just do the will. Just remember, though, that doesn't avoid probate. Only the trust does. But yeah, if you just want to do the will, absolutely, you can just do that.
Fantastic. I think I do see one more question, follow-up question kind of a things. Meenakshi, I want to know more about this trust. I think like Mark covered about the trust. Like, do you have any further follow-up questions, Meenakshi?
Yeah, I mean, that's the, I think, same thing which he explained earlier, that if we don't do trust, what will happen? I mean, if we don't do only will, what is the like implications if we don't do that will trust? And trust, is it like different for each city, I mean state, or it is like similar kind of rules it has?
Yeah, so each document is state specific. So, you know, what my document reads in Kentucky, where I'm from, may be totally different from where you are. Now, a lot of the rules and regulations are the same, right? The time period will be different, but still, you know, when you create the trust, it's going to get those assets to your beneficiaries. But the wording in every document is different according to what state you live in.
Okay. So like, as what I understood, like if we don't do the trust, our beneficiary, if we do it trust, then our beneficiary will get immediately property. They don't have to go to like lawyers and anywhere, right? I mean, that's the thing, right?
Your executors can make sure that they receive those assets right away. Now, you do have to wait like, you know, probably about a month to get it, because, you know, probably 10 to 14 days you're waiting on the death certificate. Then you have to get with the company and they have to do their paperwork and then get the documents to you. So you're looking at probably about a month to receive everything, as opposed to up to a year by not doing anything.
Okay.
Great.
Okay, thank you.
Yeah, the next question, what will be the case when the person has property in more than one state?
Yeah, you just need one will and trust for your primary residence, and you can still put those other properties into that state's documents. You would just do your deed transfer in the county of where that property lies. And you can just call them up and they can help you do it over the phone, or they usually will just mail you a new deed for that property.
So what I'm hearing is that like only one trust where the person resides, that is sufficient.
Yeah.
And if the person is having the property at multiple states, so each and every property, he has to create a deed, and he has to file the deed in the respective counties where the property exists.
Yeah, and you can just go to the county clerk's office and they can help you do everything.
Absolutely. Thanks, Mark.
Yeah, and we have the funding instruction sheet that walks you through all of that.
Absolutely. Yeah. there is an instruction as well. I think like you can just go
Yeah.
through the instruction and follow through that and see how to fund the trust.
Yep.
That is also available. The next question, can I assign guardian from India if we don't have anyone in USA? I think like Mark already answered that. Yeah, you can have a guardian in India, but ensure like there is somebody local here, so that like if the person from India is not able to like travel here for some other reason, the other person can take over from here. The next question, are there any tax implications when we set up the will and trust? I think like the same exact question, like a couple of other guys also asking Mark.
Yeah, we get that question every time. No, so there's no tax implications on this. You'll file your taxes as you always have in your individual name.
So Mark, like follow-up question on that. Say for example, like we are giving a successor trustees. So when the initial trustees are gone, the successor trustees, they will control the trust and all the assets. So will they have to like file the tax on behalf of them? How is that?
Well, that's the role of your guardian, or I'm sorry, your executor. Your executor will handle all the filing of all taxes and everything.
But will it be considered his income? Like whatever the
No, your executor never takes ownership of the property. They just make sure all the taxes are paid, and then that asset gets distributed to the beneficiaries.
Okay, absolutely. I think like that is a great answer. I think like a lot of people know asking for that. Vinith, any follow-up question on that, Vinith? I hope you are good.
Yes, thanks. It covers what I had in mind. Thank you.
Fantastic. Thank you. Okay, the next question, if I change state, do I need to prepare documents again?
Yes, anytime that you move states, you have to complete all, just go back into your account, change your address, and the software will update to the new state's documents, create the documents again, print them out, and get them witnessed and notarized.
Okay, the next question. If we added a property to one of the trusts, what if we have to sell the property?
That's fine. You can still sell it at any time.
But do they need to carry anything else other than the trust document or something like that? Like,
No,
right?
Even if the property is owned by the trust, you can sell that property out of your trust. I just bought this house about 2 years ago. Old house was in my trust. I sold it out of the trust and bought this one and put it right into the trust.
Okay. Thanks, Mark.
Mhm.
If an asset exists in a foreign country, would the will and trust have any jurisdiction over the foreign asset?
No. You're just listing all of your properties in your will, so your executor knows everything that you own, so no asset gets left behind. These are U.S. documents only. They would not hold up in any kind of India court of law.
So in that case, like any properties which is there in India, probably people have to take a will separately in India, right? Like
that's usually what they do. So they'll set up their will and trust for their U.S. assets, then they'll set up a will over there for their India assets. That's usually what most people do.
Absolutely. Thanks, Mark, for that clarification. Mark, like one other question, like people yesterday, I was meeting a customer and they were asking. So there is a will everything is created and it is notarized. When the person's passed away, do they need to have the original copy of the will and trust document in order to claim the property or do any transaction, or the Xerox copy is enough?
Yeah, no. So the great thing is, so once you print out your documents and you get them witnessed and notarized, so you have your hard copy, right? But in our plan, what we want you to do is scan those back into your NetLaw plan, because there's a section called My Files where you can store all of your signed and witnessed and notarized documents. And you can email those to your executors, to your guardians. If needed, they can use a digital copy of that in a court of law and it will hold up, as long as they have the signed, witnessed, and notarized copies.
Okay, so nobody need to hold the original copy of the will, right? Like, so even the hard copy or soft copy.
It would be nice. It would be nice if they had that, but not necessary, as long as they have a digital copy that's witnessed and notarized.
Fantastic. Thanks, Mark. Thanks for that. Okay, I think like there is a question about the cost of the package. Probably the original cost of this package is $600. So there's a promotion going on right now, like until March 15th. If you take the package from us, so we will do it for like $299. The offer exists until March 15th.
Wow. That's a good deal.
Yeah, Mark. I think like people has to make use of this opportunity. I think like otherwise,
Absolutely.
after March 15th, this goes up to $600.
And just for comparison, this starts at $3,500 in our law office. Starts.
Wow, what are the difference? Like fraction of that only we are paying here.
Crazy.
Just 10%. Yep. If it is
10%.
taken like within like March 15th.
Yeah.
Yep.
90% discount.
Great. Like other questions, Mark, what about will the beneficiary automatically become a trustee when he becomes 18 or 21 kind of an age?
No, you would have to log back into your account and make them a designated authority.
But again, like if the person passed away and when the kids become 18 after that, when the person passed away,
They do not.
They will not.
No.
So the successor trustees will do all the things, like if they
Right.
want to settle everything, they will settle and give it back.
Whoever's named in the documents, they'll handle everything.
Okay. So like say for example, if there are multiple successors assigned as a successor trustees, what if one of the successors are not able to travel or are not available?
Yeah.
What happens?
Yeah, so there's two options when you're naming your successors. You can do multiple people serving together. That means it's just a majority. So if one person can't come, then they can't make a vote and the others will decide. Or you could do multiple successors, but one serving after the other. So the first person, then the first person, then the next person, and then the next person, like that. So it's usually majority wins.
But how do we prove like the first person is not able to come and only the second person is available kind of?
Well, then he would make that decision.
Or when they go to the court or something, like whoever is available.
Yeah, well, the successors won't go to court. They're just handling everything in the trust.
So, but then what if there is a dispute comes in? Like the first successor is not available and the second successor, he is making all the decisions and all. And the first successor comes into the picture after like 6 months or something like that. So what happens in that case?
Yeah, then they could start coming together and talking about it.
Okay.
Yeah, that rarely happens. If one person disappears, they're not coming back later.
But for some reason, like if they are not available and they're coming in later part, and like will there be any legal dispute kind of things will happen? Like how?
No, that's why we have successors. If the first person wasn't handling everything, it falls to the successors.
Okay. And the second person has the authority to
Correct.
make decisions. Okay.
Correct.
Fantastic. Okay, I think that's all I have it from the list of questions listed here. Let me see like if there is any more questions. I think we handled pretty much. Like anybody else in this call now have any other question?
Hey, I have a question. Just to ask, like, if my home is added to the trust, whether it has any implication on changing the mortgage or refinancing?
Right. Yeah. No. Your mortgage will stay in your individual name. So when we're talking about transferring the property into the trust, we're talking about a deed transfer. So right now the deed is in your individual name. And what you do is you go to the county clerk's office. They will do a deed transfer for you. They'll create a new deed. But instead of it being in your individual name, it's going to be in the name of your revocable living trust. That's all you have to do.
Thank you, Mark.
Okay, I see one other question. Like, can we add property after we created the will? Yes, absolutely. You can add the property after creating a will.
Yes.
While buying the property itself, no, like the trust, if you want like park it under the trust while buying the property, at the time instead of registering the title in your name, register in the trust name, so that that becomes easy. You don't need to do anything else. Okay, anybody else has question? I think like we are almost like have just 10 more minutes left. Any further questions, please ask. Mark's time is very valuable, and we have another 10 minutes for Chandru to talk about the notary. Anybody has any last questions?
Something like just to add, like, do we need to inform the bank in case if we are like changing it from our name to the trust name after purchasing the home?
Yeah, so if you want to put your bank account into the trust, you would go to the bank and just change the account of the checking account or the savings account into the name of the trust. But I tell you, I think it's Karthik that asked that question.
Yeah, yes.
The best thing to do would just be for your bank account to put a named beneficiary on your accounts. And anything with a named beneficiary attached to it will avoid probate automatically. So you wouldn't have to go through changing everything. So if you just go to the bank and add a named beneficiary to your account, that'll solve everything.
Yeah, sure, Mark. But I think what I try to ask is like, how about for the home? Because
mortgage, you know, like
the mortgage is on the
for
bank.
the mortgage, no, because the mortgage is staying in your name.
Okay, yeah, sure. Thank you.
I think like one other question, do I need to register the will and trust in the local county?
Yeah, no, that's the role of your executor after you pass away.
Yeah, only thing is that like registering the property, if you have a personal property, any residence kind of things, the title needs to be changed. While changing the title from your name to the trust name, that is when you have to go to the county and change the title from your name to the title.
Yeah, and they'll file it for you. The county records department will file it for you.
So is this like a silent deed title change, Mark?
Yeah, you'll create your you'll have to pay for the deed transfer. I think mine was like $79. And then I paid like a $10 filing fee. So it was still less than $100.
Okay, I think like thank you so much, Mark. Like Senthil, Priya, anybody has any further things from you guys?
Oh, thank you very much, Mark. It was an eye-opener session for us. So I think pretty much whoever asked questions, these were very meaningful questions. And I'm pretty sure they might have further questions. So definitely, we will reach out to you. But thank you very much for your valuable time.
Yeah, thank you.
Yeah, so now we can turn over the table to Chandru, who can cover about like how to get the things notarized. Mark, if you can stay for a little more, like we can wrap up as well.
Yeah, I got about 3 minutes and then I got to hop off.
Well, good. Thanks, Mark. Chandru, it's all.
Yeah, sure. Without any delay, so I'll quickly go over the notary part. Yeah, thanks for Mark for coming here and presenting this opportunity. This is really helpful. Thanks to Suba and Senthil.
Thank you, sir.
Yeah, sure. So I'll quickly go over the notary. So notarization is one of the important steps you have to do, right, when completing the document. Once you printed all the documents, basically one-sided, right, you want to get with the notary public to notarize the documents. So then only it become like a legal document, right? So basically the whole process would take 1 hour because there is like a list of documents, right? Anywhere between 12 to 14 sets. Okay, so these are the important steps it covers. Basically, you would need to notarize the documents in front of 2 witnesses. So it's better to always call the notary public near you. Also, Suba also notary public. You can have the notary public at your home and then bring 2 witnesses, right? So the witnesses cannot be in the document. For example, if you put someone as an executor, then the executor cannot be the witness. That is someone, has to be someone else. Also, the witnesses has to have like a valid ID, US ID. Okay, and another thing is the notary generally cannot give any kind of legal advice. All responsible for verifying the signer, right, and recording in the signer detail in the notebook, notary journal, and then notarizing each page. That's all pretty much it. And also you want to just print the document in a regular paper to one-sided, basically. Okay. And all the signature has to be done in front of a notary. So please don't sign, before, notary comes in. And also there are some addresses section in the document. You can fill those address section. So that will make it quicker, the notary process. Okay. What I have seen is like it will generate anywhere between 12 to 14 sets of documents for husband and wife. So depending on the state, right? As I mentioned before, it's going to take 1 hour minimum. Sometimes it takes longer. All right. Yeah, these are the detail I just want to quickly cover. Anyone have any question on the notary side? Let me know. Otherwise, we will tend to send them.
I don't see any questions in the chat. Yeah, anybody know, like the forum is open?
Hey, this is Thiru. I just have one question. Sorry.
Yeah, go ahead.
It's too late. Yeah, so about this software, right? So do we have any help desk or customer care kind of, if we stuck somewhere and we don't know how to proceed further?
Yeah, Thiru, like
get any
there
help?
is a video, like we will share a video on how to complete the documentation kind of things. And also, like in case of any further questions, like Mark can talk on that. But again, like you can chat like 24. It's not 24/7, but almost like you can just chat there and get the queries clarified in the portal itself. And also, like we do provide support. Like in case if you have any questions while filling, just reach out to me, Chandru or Suba. We will help you as well. There is a support available for your question. Yeah. Thiru, did I address your question?
Yes, I'm good. Thank you.
No. Any further questions, folks? We still have like 4 more minutes.
Are there any hidden costs or anything else other than $299 that you mentioned?
Yeah,
$299 paperwork cost.
Yeah, $299 is for the package. So it is for both the husband and wife. So there is no hidden cost. Like when it comes to like any specific cases you have it, that is a different thing. But again, no, like a generic will and trust package, it's $299, and you need to get it notarized. Yeah, notary will charge for the notarization, but otherwise, no, like there is nothing. And also, no, like as Mark already covered in his session, lifetime, no, like you can just generate the will and trust package as many times as you want. Say, for example, you are making some changes to the address, or you are making some changes to the successor trustees, guardians. Even you move out from one state to another state, your will and trust no documents has to be regenerated. You guys can go ahead and regenerate and get it notarized. I think like each and every times the software is free. Like lifetime, you can do as many times as you want. But the only thing is that whenever you're making the changes, you have to get that printout taken and go to a notary, and notary will charge whenever like you are going to the notary. That is the only thing. There is no other hidden cost, Kavi.
Okay, thank you.
Sure.
All right, Santa, I'm going to have to jump off here and get ready for my next meeting, but I want to say thanks to everybody who joined tonight. Hopefully this was very educational for everyone. And again, when you're ready to get started, definitely reach out to whoever invited you here, and they can get you the link to get you started.
Thank you so much,
Santa,
Mark.
I went ahead and made you host, so you have control.
Sure, Mark.
All right. Thanks, everyone.
Thanks again. Good night.
Thanks, Mark. So, Senthil, do we have any other things, or the pretty much the session is done?
Session is covered. If there is any further questions, we can just like address it. We have a couple more minutes, otherwise like we'll end up the call.
Okay. Yeah, well, thank you very much, Senthil, Chandru, and of course, Mark. And within our region, like Suba is there. So I think for any questions, we are going to reach out to her. For Suba, you have any words to share?
Thanks everyone to spend your time and joining for the call. And we have a workshop on March 10th and March 9th and 10th. So if anybody interested, please reach me or send an email or send me a text message. We can help you to cover the complete process, how to start the will, and it's a simply 3 hours workshop. Bring your laptop and we help you to do the will and trust completely.
Yeah, you can complete then and there, like the will and trust, no, like the entire package. Chandru will be there and Suba will be there as well.
Okay.
And people can get benefited, like then and there. They will help to how to complete and all. Otherwise, you have to go through the video, all those kind of things. So you can avoid all those things. And even notary, like both of them are notary. Chandru cannot notarize it, but again, Suba can notarize then and there. So people can complete the entire process within the 3 hours. So they don't need to go back home and like skipping it for another year or 6 months kind of things. They can finish it then and there. So like probably you may want to like send this message across so that like people will get benefits until.
Sure, definitely we will do that. We are glad that we have one person in our area itself. So Suba, congrats and thank you very much for helping out to arrange for this session. You and Ram. Yeah.
Thanks for the opportunity to given me from the Mnts. So really thankful for Mnts.
Sure. Thank you.
And last information, and March 9th Saturday, we doing workshop on Woodbury, and March 10th on Eden Prairie Library. So if you
March 9th, what is the timing?
It's 1 to 3 on March 9th.
1 to 3?
At
Is it 3 to 5, right, Suba? I thought it's a different time.
1 to, yeah, sorry.
Okay, you can later on confirm too. So
Yeah.
I was just asking because we also have a Women's Day celebration on the same day, March 9th. So I was just checking on that. But yeah, ours is 5 to 7. But yeah.
And we have a session on March 9th, Saturday, and 10th on Eden Prairie.
Okay, good.
Do we know where in Woodbury it is happening on March 9th?
March 9th, like I think like can you post it, Suba, like the information about the next session on March 9th?
And also, is it possible to get this recording if we want to revisit this?
Yeah, definitely. We will share it across. I think like we will upload it in some of the Mnts portal itself. I think I will share it with Senthil, and Senthil probably like whatever the things he has to take care from there.
Sure. Once if you share, I will upload it in our YouTube and make it public for whoever has registered.
Okay, thank you so much.
Thank you.
Suba, you want to share your number here, like last page or something?
Yeah, I already shared on the chat. It's 732-881-2136. 732-881-2136. And Woodbury, it's a Woodbury Library, RH Stafford Library, and 8595 Central Park Place, Woodbury. And Eden Prairie, it's a Hennepin County Library, 565 Prairie Center Drive, Eden Prairie. It's the address.
Okay, thank you.
Yeah, sure.
All of you, like who is watching the video, please reach out to Suba at 732-881-2136. Thank you. We are winding up the call.
Sounds good. Thank you very much, Senthil, Chandru, and Suba. It was a wonderful opportunity on behalf of Minnesota Tamil Sangam. We heartfully thank you.
Thank you so much, Senthil, Priya, and Mnts.
Thanks, everyone. Thank you. Bye.
Thanks very much.
Bye.